Hi, Wes Scott from Lifeback Law Firm. Today we're going to talk about 2025 bankruptcy and student loans. Where are we at? Folks, there's a lot of people who ask us about student loans and bankruptcy, and just straight out, going to tell you that the bankruptcy code across the country, it's the same, which is student loans are not dischargeable in bankruptcy unless, one very narrow exception, unless you bring an action against the student loan company, a lawsuit, in the bankruptcy case, and you convince the court that the court should enter an order discharging the student loan debt because it creates an undue hardship on you or your family. Now, there's case law all over on what's undue hardship. And I think it's all over the board, to be honest with you. I still think this is a little bit of the Wild West. I mean, with student loans and the frustration from our point of view, excuse me, is student loans are an unsecured debt normally, and they are not dischargeable in bankruptcy, but there's rules in bankruptcy that say you can't pay student loans before general unsecured debt. It's not right. It's not right. You shouldn't say student loans are not dischargeable, but you can't prefer them. You can't, they're the same as a credit card. No, they're not the same as a credit card. Credit cards are discharged in bankruptcy. Student loans are not. They're not the same. But the code doesn't see it that way. The code sees it that they are in the same class, unsecured creditors, and therefore you cannot, under the code, discriminate against the treatment of one versus the other. In other words, they got to be the same treatment. If MasterCard gets 50 cents, the student loan company gets 50 cents, et cetera, et cetera. I'm oversimplifying this, but it's been a frustration. It's a little bit like the Wild West here with student loans and bankruptcy. And the reality is, in the bankruptcy code, this procedure to discharge student loans is a narrow exception. You have to go first. In other words, you have to spend money first. It's like the casino, right? That the casino doesn't go first, you go first. You put up the money and then figure out whether you got a shot at this. I mean, it's a crapshoot. And to me, unless you're older and sicker, forget it. I just forget it. I'm not sure. I wouldn't spend my money on it. Now, that's not to say outside bankruptcy there's not options. Government programs and private programs, and there probably is. But in bankruptcy, they are not dischargeable unless you bring this narrow exception. And in this environment right now, we're just telling people don't do it. Don't do it. Don't spend your money. Now, what should happen in bankruptcy is student loans should be figured out, and they should be discharged. In my mind, student loans should be discharged if you are in a repayment plan of, say, 5 to 7 years. It's discharged. Make it what you want. 10-year program. I've lobbied Congress on this. Create a provision, create an escape hatch for people with this thing. If you file a bankruptcy and pay your disposable income for a period of, say, 7 years, the student loans are discharged as well. It's the way it should be. It shouldn't be an anchor around our children's necks for the rest of their lives until they die and beyond. That's ridiculous. It's servitude. We've outlawed this. So it's frustrating. And call your legislators. Tell them you want to see student loans discharged in bankruptcy. And I think that's the answer. I think it's a Chapter 13. You're going to do a Chapter 13. You're going to pay for X number of years, and then it's going to be a super student loan discharge, bankruptcy. Call it a student loan bankruptcy. When the time is right, when you are ready to get your life back, reach out to Life Back Law Firm, Minnesota's most kind, most helpful bankruptcy law firm.